So much for coming in.
Thank you for having me.
It seems like almost a lifetime ago, but it was really just last October that the Me Too movement began. How much of, I suppose, this newfound sensitivity and awareness to sexual harassment in the workplace is a product of this Me Too movement?
I think it's very much attributable to the movement, the Me Too movement. We have New York State and New York City coming out very strongly in favor of promoting policies in the workplace that protect victims of sexual harassment. I'm proud to be a New Yorker, in fact, with all these new regulations that are in effect regarding training, regarding policies for sexual harassment that will actually help aid employees who have suffered from sexual harassment in their fight against the harasser and being able to file a complaint within the internal department of their company or outside of the company as well.
I think it's probably easy for employees to think that they know everything about sexual harassment and think, well, I would never do anything like that. But is there a gap education-wise between what people think they know about sexual harassment and perhaps how to intervene and help prevent it?
I think there is a gap, and I think part of what they've done in New York is try to close this gap.
Yeah.
In the policy itself, they're going to identify what sexual harassment is. It's unwelcome conduct. It can be physical, it can be verbal, it can be visual. Mm-hmm. And it's in that setting, it can create a hostile work environment if it's severe or if it's pervasive. So a lot of people think, well, the obvious type of sexual harassment would be attacking somebody
right.
or grabbing somebody, but nonverbal or visual harassment, if it's looking somebody up and down, or licking somebody's lips suggestively, or cornering somebody if they feel intimidated, or even displaying like pornographic images on a computer or listening to music that's inappropriate. All of these things can constitute sexual harassment. And New York State has said in the policy that an employer has, they should identify specific examples of the type of harassment that could be actionable.
And this kind of speaks to your previous point, but what you just mentioned, those are things that perhaps not everyone realizes the harm that it could do. So how important is it to have that specific strict language when it comes to sexual harassment policies?
I think it's very important, and sometimes it's difficult for HR departments and employers to identify the amount of conduct, the type of conduct that actually constitutes harassment. Courts typically will look at the totality of the circumstances, the frequency of the occurrences of the sexual harassment, the type of harassment, how the employee was impacted. So all these different factors go into what courts determine whether or not there's been sexual harassment. And employers need to know, like, if there's a complaint that's been filed, which is part of the policy, they're required to have an internal complaint procedure so that when somebody is experiencing sexual harassment that's unwelcome, that's the first part of this. You have to say, look, this is not welcome conduct. Right. This is sexual harassment. And then they have to have a procedure where they go in and they file a complaint. There's actually a sample complaint form on the New York State Human Rights website, and I think on the New York City Commission's website as well, where an employee fills it out and says, look, I've been impacted by this supervisor's behavior, and they fill out the facts of the harassment, and then the company will launch an investigation, independent investigation by their HR department or by a supervisor in charge. And that's a confidential investigation where the facts are all reviewed, and then they're reported to the employee. It's kept confidential between the parties involved, and they interview witnesses who may have witnessed the conduct.
And for a long time, victims may not have known where to turn, and it may have seemed easier or less painful for a victim to simply not report an instance of sexual harassment. But what this law does really, as you mentioned, is lays out the plan and the framework, right, so that for a victim, it maybe becomes easier. They know the channels and the options that they have.
Right, and it's always difficult for a victim to come forward because they're concerned about their job and how it will impact it. But having an avenue for a complaint process, having an independent investigator conduct an investigation, knowing what the policy is, part of the requirement is to actually set forth an actual policy against harassment, identify the examples, have a policy for non-retaliation, meaning if you bring a complaint, you're not going to be retaliated against with a demotion or with a termination. You're going to be able to keep your job. If you're a witness to an incident of misconduct, you also can participate without being retaliated against. And also part of the policy should be, look, if you aren't able to resolve this through the internal complaint process in your company, then you have other avenues. And part of the policy for New York State, it says that you have to be able to say, look, we have a federal avenue, we have a state avenue, you can file a discrimination charge with the EEOC, which is the federal venue, or you can go to the New York State Human Rights Commission, or you can go to New York State Court, and there's also local laws that protect you. So employees become more informed about their remedies that are available.
And then empowered to take action if they so choose, if they were to become a victim.
I think with having that policy in place, and also as you mentioned, the training that's required, interactive training, where an employee is actually viewing different examples of harassment in the workplace, they're going to be able to, interactively check off that they've seen each of these slides and sign a policy saying that they understand the training and they understand the policy that the employer has in place. And yes, then they have the company behind them to try to go against some of the bad actors that might be harassing people within the company.
How significant do you view the evolution in sexual harassment training? I think many of us who have been in the workplace for a few years now can recall being hired, starting a new job, and then maybe you're required to watch a video or read a pamphlet prior to your first day. But with this training that will begin in October, there's that interactive aspect. It seems fresh and different.
I think it's fresh and different, and it's important for people. Sometimes you can just sort of watch a program and be or see a presentation. You're not interacting and providing active examples and actually being required to click through something and show that you're actively participating, which is so important because you're digesting information and you're learning the complaint process for filing a complaint. Should you be harassed? So it's important to be interactive and important to actually be involved in the process so everybody takes ownership of it. Part of moving past what's been going on with the whole Me Too movement is the secrecy. Yeah. So bringing it out in the open, having a policy that protects employees, and it also helps the company because the company is acting proactively. They're acting before an investigation happens, and they're acting preventatively to stop any sort of harassment that might occur. So I think it's good for both employers and employees to have these policies.
So do you think that this will have a real tangible effect in changing existing behaviors? Or some people may say that this is really just this legislation is a way for employees to cover themselves from potential lawsuits.
I think it will have an impact. I do. There's also other provisions that have been put into place in New York where you have a situation where it used to be employees that were protected, but now independent contractors that are involved in the workplace and have a contract with the employer, vendors, if they're present and they're misbehaving and harassing employees at the workplace or other people at the workplace, the company can now be liable if they're harassing other employees. So there's all these different laws that are coming into effect to actually assist in weeding out wrongdoers and trying to get into a preventative approach in the workplace.
Are you satisfied with the language in this legislation, or could it go even further?
I mean, look, the legislation does not cover everything. As I mentioned, they have the new provision for vendors and independent contractors to be covered. There's also something which I think is great in the law now, talking about non-disclosure agreements, because typically victims are silenced when they enter into a settlement agreement. They have to sign a provision that says they will not disclose the contents of the agreement. Well, that's disfavored in New York now. That's unless an employee says, I prefer to have this provision in the settlement agreement, it's not required. In arbitration provisions, where employees are supposed to be mandated to go to arbitration rather than have their case heard in court, that's also another provision that's being challenged, although the federal law at the Supreme Court level has ruled differently. But all of these changes are positive. Some things, as I said, are not covered, like dating in the office. Right. Sometimes it's advisable to have a policy about inter-office dating. If you're going to date another employee, there's potential for harassment issues. So you may want to have those employees assign some sort of acknowledgement that they're dating and figure out a policy to work out if they really want to date, how to handle that in the workplace.
Before we let you go, do you think that there are more subtle forms of sexual harassment in the workplace that this legislation, this training, would really help root out and change behaviors on? Maybe overlooked aspects of sexual harassment?
I mean, I think the overlooked aspects are the more, as I mentioned earlier in the program, more subtle instances of harassment. You're not going to be able to cover in a policy every single type of harassment, visual, nonverbal, verbal, physical, that could arise. So the trickier circumstances might be something like a visual type of harassment where somebody's looking you up and down, and you know, how do you interpret that as an employee? If you feel it's unwelcome and you feel that it's actually harassment, and in part it's also part of a larger whole of other harassing behavior, like asking you out on a date, or you know, or showing
Just
you images. So I think I think those are the trickier parts of the law, and trying to get people to comply with.
It's a start,
parts.
though.
It's a start. It's definitely starting a very good start.
All right, Kathryn Barcroft, thank you so much for coming in.
Thank you very much.
Nice chatting with you.
Thank you.